We know that prior to a year ago, Google was phenomenal in the fact that they could provide us information not just on someone's keyword searches, not just on what emails were being provided, sent to and from that individual, among various other things, but they also could provide us location information, even if we didn't know that account holder's email address or IMEI number, and we could fence off an area, and that they could determine who was in that specific area. And the way they did that was typically by cell site information, Wi-Fi, as well as assisted GPS and Bluetooth. These are technologies separately that have been generally accepted in court for some time. We know that judges and jurors tend to give this data a lot of weight in court. In fact, they value it in some ways more than DNA evidence, at least according to a few recent studies. But what we also know is that when geofences came out in the 2016-2017 year, that they were eventually subject to a lot of legal challenges. And they were particularly in the Illinois area, and then they crept down the Midwest in the Kansas area and eventually ended up in Virginia. There was and there is an excellent paper from the Scientific Working Group on Digital Evidence on reverse location data. The link is on the slide in front of you as well. And what do we glean from those cases is that we not only had to establish probable cause to believe that a crime or crimes were committed, but we also had to describe the geofence process and how that evidence would be obtained insofar as identifying the Google subscriber. Many of you may remember a three-step process. In many ways, it was a four-step process because after that third step, you got the account holder information, but to admit it in court, you wanted to get that fourth step in and get all the information from the account. It was easier to present a trial in that regard. You also had to describe, based on the case law, that either you knew a phone was being used through surveillance video or through any number of means, a co-defendant statement, what have you, or you had to rely on if people were working together, based on the affiant's training and experience, a phone was likely used because individuals use phones in order to communicate. You also had to narrow the geofence based on time, location, and scope. The concern of the court was that we were getting all this information from innocent people, and we needed to essentially curtail defense to what was absolutely necessary. Something that I think we all can appreciate. I don't want to get innocent person's information, but nonetheless. Within the past year, for various reasons, Google said, hey, we're not doing this anymore. We're moving it from what we have to the user of the cellular device, typically the cellular device in this regard. So what do we do as a result? Well, there is an organization many of you may be familiar with called ERAD. You may be familiar with it because if you have credit cards and you need to figure out what's on the magnetic strip, if it matches the front and the back, ERAD offered that service and offers that service. They also have some forfeiture angle to that. They also are offering a service where you can do something akin to a geofence, narrow off an area, and then from the user perspective of a cellular device, somebody consents to their location information being shared. And this technology leverages the fact that the person consented to sharing their location information as part of using the program. The legality of this program, however, hasn't really been fully litigated, but it will be litigated from a consumer protection standpoint, as well as to our traditional Fourth Amendment case law. But it offers hope insofar as if it is challenged to possibly bring back Carpenter versus U.S. before the Supreme Court. The other area where, due to the end of geofences in many regards, we also can leverage is traditional cell sites, and in particular, RTT data. Now, the concept of RTT or round trip data is not, it's fully known. It's fairly easy. Our phones communicate with the tower, and the tower sends a signal back. The speed of the signal is known, and then ultimately it can be mapped based on algorithms held by the provider. The RTT data may be known by different names depending on the provider, and it's kept for a limited period of time. For AT&T data, it used to be known as NELOS data. It's now known as LOCDBOR data. The newer name actually is reflective of better technology that's more accurate. With Verizon, it's range to tower. With T-Mobile, it's time difference on arrival data. But it allows for geolocation within certain areas. Um, and we see that it's been accepted by various state courts. Within here. Um, Now you can get the data any number of ways. You can get a traditional just a listing of cell phone numbers within that certain range or location area. Um, or you can get IMEIs in order to protect the information and narrow it down to one or two IMEIs. But the same principles that we found within geofences are likely to remain when we do these RTT data warrants. They are very helpful, but we do anticipate more challenges in this area, and we should be aware of those, and we should welcome those challenges, provided that we know the science or we rely on people who know the science to explain it within our warrants and then in our motion practice. And I think then it's okay, we don't have the geofence anymore, but we have equal technology that can meet the challenge in our day-to-day lives and careers. For those of you who need any assistance from me, here is my contact information from work. As you can see, I used to be also a healthcare professional.